Senator Joyal.
Mr. Chair, the bill makes, of course, a distinction based on sex. It established, of course, a special system for Aboriginal women. On the basis of 15, one could argue that it is discriminatory. But don't you think that could be saved by Section 1 on the basis of the fact that Gladue already recognized the systemic condition into which Aboriginal people find themselves in Canada at this stage, that in fact the bill could survive a charter challenge on that basis?
Bill, did you want to take that, or I'm happy to if you'd like.
I find the question as complex as the argument that would be made. It's a very thoughtful question, Senator Joyal, but oh my God, I think this is so difficult to find an answer to. A challenge that hopefully is not necessary, but I defer to my younger colleagues on this, but I'm very concerned about the ramifications even of the question.
What I would do is I compare this piece of legislation with the other aggravating features in the code, and what you'll notice is very important is for every other aggravating feature, what's at issue is the relationship between the offender and the victim. So for example, was the offender the spouse, married or common law? Was the offender in a position of trust or authority? And that is what is in and of itself that's aggravating, that the accused person, now the offender, for whom much better is expected, particularly of someone who is inherently vulnerable due to that relationship, has exploited that relationship and committed an offense. This is completely different. This establishes a class distinction based on nothing more than the identity of the victim. That stands alone in the criminal code. You add another layer to it. What stands alone is that it would disproportionately affect a already vulnerable population that's in fact protected under 718. So this would be a thorny challenge, and I doubt its ability to withstand, I doubt its ability to be saved under Section 1, particularly given the fact that the government would bear the burden of demonstrating that this has not just a rational connection, but actual beneficial effect on what is being targeted here, which is the vulnerability and victimization of Aboriginal women. Would an aggravating feature on sentence really do that? It doesn't do much in any other cases. Why would one expect it to do anything in this circumstance?
And Senator, I would say, we've already heard one comment about signaling, right? What signaling would it send? Because I think the only way you can make a plausible argument for a Section 1 save of this kind of argument in the face of Section 15, the equality provisions, is to say that Aboriginal women as a class of people have to be labeled as a class that requires special protection. And while the statistics, to some extent, bear out the reality of that, the saying of that, I would be concerned, and it's difficult for me to say this as a white male, but I'm here, you're asking me, so I'm going to say it. I would be concerned about what that signals to the entire population of Aboriginal women, which is we have designated you a group in need of protection, so much so that we save an otherwise unequal law. I don't know whether that's a short-term solution or what that means in the longer term when the state sanctions that kind of commentary, if a court even allows it to get that far.
Thank you.